Greetings everyone, welcome to Lex Prep. This is the lecture 3 of Arbitration and Conciliation Act 1996. I am back with you, and in this particular video I am going to discuss about the Arbitration Agreement section 7. What is the meaning and the scope of arbitration agreement? And it has somewhere around, we will find section 7 has somewhere around 5 subsections. So this is something that we always check first whenever we are referring to a section. Now, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen, which may arise between them in respect of a defined legal relationship, whether contractual or not. So, what is important is that there must be parties with a defined legal relationship. With a defined legal relationship. Now, the scope of this legal relationship can be contractual, given in a contract, or any other agreement. Or any other agreement. Right. So, this particularly also includes oral agreements. Now, that is something to be seen that whether oral agreements can be referred to the arbitration. Right. This question comes because the any other agreement means that immediately कॉन्ट्रैक्ट आर्ट के कंटेक्स्ट में हम रिलेट करते हैं तो हमारे दिमाग में ओरल आता है. लेकिन आर्बिट्रेशन के इसी सेक्शन में आगे आपको खुद ही एक्सप्लेन कर देगा कि आर्बिट्रेशन एग्रीमेंट शैल बी इन राइटिंग. Arbitration agreement shall be in writing, which means the scope of this any other agreement must also be a written agreement. So any other agreement can be there. It can be whether predefined in a contractual relationship or not, but it must be in the written format. Now, arbitration agreement may be in the form of an arbitration clause. That's one in a contract. So one of the clauses of a particular contract can include the arbitration clause, or in the form of a separate agreement altogether. So there can be like two sets of contract. First is your contract and the second is the arbitration agreement, right? This is included in it. And subsection 4, the arbitration agreement is in writing if it is contained in. So what is the scope of this written agreement, right? How it must be, right? And what are the particulars that has to be kept into account, or what shall be considered to be an written agreement, right? Like we discussed here. So the subsection 4 defines a document which is signed by the parties. So it must be signed by the parties. Now the subsection 4, clause B says exchange of letters, telex, telegrams or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. So what is important is the record of the agreement. Anything that provides the record of the agreement, and it must be signed between the parties. These are the two requirements that are given, right, as clause A and clause B of section 7 subsection 4, right? An arbitration agreement is in writing if it is contained in. So these are the two things which must be there. Moving further ahead, we'll find that there is also the third component, any exchange of statements of claim and defense in which existence of the agreement is alleged by one party and not denied by other. Now this is something like left to interpretation, isn't it? Don't you think? So how to interpret it? Illustrations are the best way. So let us try to understand it by way of an illustration. Now illustration says that there is party A, there is party B, and let's say they are under a contract, and on so and so date party A communicated to party B by, let's say, email, that we are facing with an issue that needs imminent redressal, yeah, imminent address, and to that let us refer the matter to arbitration as we had priorly discussed, right? And let's say B gives a reply to this email by just saying that no such issue is there. No such issue is there. So, in this particular message, he has not denied that there was no agreement prior indicating that arbitration shall be the usual redressal method. Now, this is where this section 7, subsection 4, clause C will help us. Whether this particular illustration, I mean the transfer of email, would cover arbitration agreement or would cover that written agreement which may give rise to arbitration. This is the question, right? So the explanation is subsection C, section 7, subsection 4, section C. It will be considered to be an arbitration. That is the agreement for arbitration. The reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make the arbitration clause of the part of the contract. The reference in a contract to a document containing the arbitration clause constitutes an arbitration agreement if the contract is in writing, number first, right? And the reference is such, what reference? Reference to the document is such as to make that arbitration clause part of the contract, which means this section 7 subsection 5 indicates that arbitration agreement, right, or arbitration agreement wala clause will be part of the contract, right? This is very important. If there is a contract and let's say they are referring to a particular document which is in the nature like we had already discussed, so which document says that it has an arbitration clause, now that is something where first we need the essential is that it must be written and the reference is such that the arbitration clause is the part of the contract. So this is the second essentiality. So far in section 7 what we have discussed, so let us try to summarize it. Now very simple.